Hello, welcome to revision tips for CIPS Level 4 Diploma in Procurement and Supply. And this is Module 3, Commercial Contracting, Learning Outcome 1, which is to understand the legal issues that relate to the formation of contracts. So we cover things like the documents that can comprise a commercial agreement, the legal issues that relate to the creation of the commercial agreements, both with customers and suppliers, and the different types of commercial contracts between customers and suppliers. So clearly, some understanding of basic principles of contract law is going to be essential when you're contracting with suppliers. And that doesn't matter whether it's a good or a service. You should still have a contract. Contracts are legally binding, whether they're verbal or written. And there's also a wide range of documents involved in contract law. So as it says here, a contract is a statement, whether it's written or oral. It's exactly what two or more parties have agreed to do or exchange. It sets out the conditions and the contingencies which might alter after the agreement's been made. The rights to each party if the other fails to do what they've agreed to do, and how responsibilities for liabilities will be apportioned, and how disputes will be resolved. Contracts and contract management also involves a wide range of documentation. So these are some of the key documents which we most frequently encounter in commercial agreements. So you've got the specification, the key performance indicators or the KPIs, service level agreements, SLAs, also the request for quote or the tender document, depending on which one you've done, the terms and conditions, and the schedules. The schedules are things like pricing, timings, the use of subcontractors, confidentiality and non-disclosure agreements. So if it was an RFQ, this is a request for a quote, which we often use for lower value transactions. But the quote received is legally binding once it's accepted by the buyer. And those forms form part of the contract. Now, an organisation will normally have a template they use for an RFQ, so that they can ask the same information from every potential supplier and make the process for producing the RFQs quick and easy, rather than creating new ones every time. But in summary, an RFQ is a less formalised process than tendering, typically used for low-value contracts. The supplier's quote constitutes an offer in contract law, and the purchasing organisation often adopts a templated approach. But if you are using an ITT or invitation to tender, they're recognised as being far more complicated and formal. And the response to a purchaser's ITT will still constitute an offer in the same way it does with an RFQ. But the ITT will be more comprehensive in detail, and the documentation sets out the process to be adopted, including things like the date and time by which formal responses must be received. Performance management frameworks are used to set and monitor levels within contract. The key components of the performance management framework are that key performance indicators state what the supplier needs to achieve in contract delivery. It's the target that indicates pass or fail. So for example, satisfaction levels of 85% or higher. So 85% is the target, 85 or below is a fail, but above will be a pass. And then finally, the consequences. What happens if the measurement is not achieved or if they're exceeded? Measuring KPIs help a buyer to identify if the standards required are being met consistently and whether performance is stable, improving or deteriorating over time. The buyer can then take action depending on what's happening in order to drive continuous improvement. So for example, if it's improving over time, elements could be transferred to other contracts. But if it's deteriorating, then performance should be addressed to bring it up to the required standards. And if it's stable, performance could mean that there are opportunities for improvement being missed. So now we're going to look at the risks and benefits of using standard contracts or templates versus using bespoke forms. So if we're looking at using standard contracts or templates, the benefits of that is that all the key areas of risk will be included, and it will prompt the drafter to think about the relevance of that current contract. You can correct the terms, which leaves less room for misunderstanding and misinterpretation. And standard lists or schedules can be attached to prompt their inclusion. But the downside is the wrong template could be used. You could result in spot checks of certain clauses rather than going through the cross checks. And things like legislation and standards can easily become out of date. The schedules may not be referenced with the right contract term, and definitions used in the schedule might differ from those in the standard contract. So using the bespoke forms, it will focus throughout that precise procurement and avoid risks that you face during the standard forms. But the risks to this is that the language may be inconsistent. There's the potential to omit less obvious areas of risks, and wider consequences might not be considered. Now, most commercial contracts are either industry standard forms or based on a template that's been developed by the organisation itself, their legal advisors, or another body like CIPS, a government department or a commercial procurement consultancy. Many contracts follow an established form: the articles, which is a summary of the basic agreement; the recital provides the context; and the contract particulars section sets out some of the specific variables. It's a mechanism for writing terms and conditions without having to amend clauses by clause. So they make up the main body of the contract and cover aspects such as payment, exclusion, liabilities, indemnities, intellectual property, and so on. The terms and conditions provide the detail, and then there's often a section for definitions and interpretations which sets out the specific meanings. And then the schedules, the project-specific details such as KPIs or the specification or the pricing. But here you can see the process that you need to go through. The purchaser will design the contract. They'll draft the contracts that they've discussed with potential suppliers in the pre-market engagement. They might refine them and then draft the contract to issue with the RFQ or the ITT. Now, quotes and tenders are normally received on the basis of the stated terms, subject to them clarifying it during the tender process. And then they're finalised once the quote or tender has been accepted. It's formally issued for signature at the very end. Now, terms and conditions should be in place for all contracts. And much of the remainder of what we talk about today explains what needs to be contained within the contract document. So as I said earlier, it sets out the obligations, the rights, responsibilities of all the parties to the contract. And it's best practice to ensure that the terms and conditions are agreed with suppliers for all contracts. But broadly, contract terms and conditions comprise of expressed or implied terms. The expressed terms are those that are explicitly outlined and stated, whereas the implied terms are those that apply whether stated or not, and it could be things like compliance with regulations. Now, sometimes supporting documentation is required to provide additional detail or information to support the contract. The documentation itself might make brief reference to the item, and further detail will be included within a schedule. So the typical schedules are pricing schedules, health and safety records, details of subcontracting staff, or confidentiality and non-disclosures. So if we now move on to looking at what makes a contract legally binding, there need to be 5 conditions that are met. You need an offer, an acceptance, unconditional, consideration, intention to create legal relationships and the intention to be legally bound, and capacity to contract. Now, an offer is a full statement of what the person making the offer is willing to provide and the terms upon which they're offering to provide it. The acceptance can only occur while the offer is open and must be absolute and unconditional. In legal terms, contracts are bargains, one thing given in exchange for another. So consideration is the thing that we're giving in the exchange. So money for goods, money for services. And the expression intention just says that you intend to be legally bound, and you can't have intention if you're doing an illegal act. And capacity to contract means the person has the legal capacity and legal competency to enter into a contract. And it's usually down to things like age or somebody suffering from mental health issues. Within procurement, it does mean that the party has the capacity to act as an agent on behalf of the organisation. But let's go through these in a little bit more detail. So an offer to be valid must be a definite, unequivocal or unambiguous statement of willingness to be bound in a contract. An offer that an offeree intends to be bound by, and it must be communicated successfully to the offeree in such a way that he or she is aware of it. And it needs to be open when the offeree accepts it. So sometimes you'll see an offer that says it's only valid until the end of next week. You can't then try to accept that offer after the time has passed. So an offer needs to be capable of acceptance and open at all times. And that means having sufficient information to be capable of accepting and not have been revoked in any way beforehand. So an example would be during a negotiation where the supplier was waiting to hear from the purchaser whether they were going to proceed or not. The purchaser might put a 30-day limit on the terms, which would be both in time and a condition. And if the purchaser replied on day 31, there would technically be no offer to accept. The process would need to start again. And similarly, the buyer could ask for different terms within that 30 days, and that would be classed as a counteroffer. And this, therefore, it would terminate the supplier's offer. The current offer would need to be accepted if whatever the purchaser had proposed, and not what the supplier has offered. So the supplier could, at any time within the 30 days, remove that offer, rescind it, and terminate the offer process. And there's a difference between an offer and an invitation to treat. The invitation to treat does not constitute an offer in law, and so not part of a legally binding contract. An offer is more specific and more obviously directed at an individual or an organisation, whereas an invitation to treat is an offer to the world at large. Another way to think of the difference is that an offer must have sufficient detail for acceptance to enter into a legally binding contract, like full details of the terms and conditions and the contractual terms, whereas an invitation to treat doesn't have all of these. It is literally an invitation to enter into a discussion or a negotiation, as opposed to intending to bind both parties. So, for example, if you was to go to buy a car from a car showroom and you saw a car with a price on the windscreen, that is an invitation to treat. It's not an offer to sell it to you because you don't know what the terms are. So here's another few examples here. An advertisement for a contract opportunity. It's not an offer, it's just saying we're looking. A price list, a price stated on a supplier's website, or a tag on an item in a shop. So acceptance must be communicated and unconditional, or it's not classed as acceptance, and thus there is no agreement or legally binding contract. acceptance by performance is a valid form of acceptance. This means that if a supplier is allowed to carry out the work in a contract or provide the goods and services, that will be deemed by the court as acceptance. So an example of this could be receiving a delivery and starting to use the contents of the delivery. A purchaser could then claim that there was no contract in place, but they'd have deemed to have accepted it by using it. Now, a valid contract must involve an exchange between contracting parties, and it needs to be something of value. And in the case of the buyer and supplier, this will normally involve goods or services in exchange for money. The court has no interest in the amount itself as long as there's something of value to be exchanged. And this is why companies are sometimes purchased for £1, or a property, it could be purchased for £1, a very minimal fee. But without it, you can't hand over something and call it a contract. It'll just be a gift because there's no consideration. So in commercial procurement, it's usually payment of an invoice or a commitment to do something. And until paid, they're committed to agreeing to the terms of the offer. The intention part is to be valid for both parties to enter into a contract. They have to be intending to be legally bound. This is generally presumed to exist if someone goes to the lengths of sending an RFQ or a purchase order. If the supplier responds to the order with an acknowledgement, it's assumed that they're intending to create legal relations. And as I said earlier, you can't have intention to a contract if it's an illegal act, like buying and selling drugs. Yes, the offer's there, the acceptance is there, and the consideration is there, but the intention isn't, so it's not a legally binding contract. And the final one, capacity. Most commonly people talk about the age of consent or something of sound mind when considering contractual capacity. And from an organisational perspective, the parties involved in a contract must have the capacity to commit the organisation they're representing. But the law doesn't specifically define what constitutes someone having capacity within an organisation. If they sign on behalf of the organisation, then the party who wanted out of the contract would have to prove that the person who signed it didn't have the authority to do so. But that would be an organisational issue of delegated levels of authority rather than a legal issue. So in commercial contracts, only the owners or the directors of a company have absolute capacity. The law says they do have the capacity regardless of how the organisation has chosen to structure itself and which it has delegated the authority, but that typically means that a purchasing manager would be reasonably supposed to have capacity to enter into a contract on behalf of its company because it's in your job description, whereas a filing clerk probably wouldn't. So purchasing staff do need to exercise particular caution here to ensure that they're acting on behalf of their organisation within the delegated authority. Now, some of the issues that a procurement professional should be aware of is the battle of the forms and the precedence of contract terms, risks presented by contracting on suppliers' terms or through oral contracts, the Vienna Convention on the international sale of goods, and misrepresentation made in a contract. So we'll start with battle of the forms. This relates to a situation where the parties have a contract or they haven't reached an agreement on whose terms and conditions will apply. And this could arise when there's a price and delivery schedule for the goods have been agreed and the goods were required urgently, but the parties are still negotiating on the precise terms. If an order for the goods is placed and the goods are delivered, the battle of the forms will ensue. So in a sense, it could be you placing an order with your terms, the supplier responding with an acknowledgement on their terms, and then you're going backwards and forth. And it's usually the supplier that wins this battle because they can send in their terms with their delivery. But it's basically the last terms that are on the table. Unless you reject them, it's seen as acceptance. Now, as a general rule, the purchaser is most likely to lose out of the battle. But here is an example of a sequence of events between a purchaser and a supplier where no terms and conditions have been agreed in the transaction. So the purchaser sends an inquiry to the supplier making reference to their terms and conditions. The supplier replies with a quote including theirs. The purchaser places an order but yet again refers to their own terms. Then the supplier acknowledges receipt, again issuing their terms. Supplier dispatches the goods and issues a delivery note, again stating their terms. And finally, they issue an invoice which refers to its own terms and conditions. So at this point, if the purchaser starts to use the goods, the supplier's terms and conditions will win, as they would have been in place at the point of the transaction, and the purchaser is deemed to have accepted them through usage. So this uncertainty could be avoided because the doubt of whose terms and conditions are in place leave both parties exposed to significant risk. And from a purchaser's perspective, the easiest solution is to ensure that suppliers are signed up to their terms, which will override any other terms and conditions that may be referred to. The difficulty with this, of course, is the supplier has greater power and leverage than the purchaser, in which case they may insist on their terms being used, and the purchaser will have no choice to accept. Oral contracts between the buyer and supplier are legally binding as written contracts, and that's apart from the purchase of land and property in England. However, written contracts are preferable as they provide an audit trail and clarity in the event of a dispute. So the risks are that the different parties to the agreement might have different interpretation. Misunderstanding may lead to conflict and commercial and contractual disputes. You may disagree or potentially agree to disadvantaged terms. That lack of written terms is a risk against which compliance and performance can be measured. There's no transparency or audit trail, and lack of evidence in the case of litigation. Now, by no means global standard, the Vienna Convention on the international sale of goods has been widely adopted. There is a link in between the Vienna Convention and the Sale of Goods Act. So the United Nations Commission on International Trade has devised a framework to provide at least a degree of harmonisation in international trade transactions. It hasn't been adopted by the world trade nations, but it attempts to address a number of key issues for importers and exporters. So, for example, it clarifies when the offer and acceptance becomes effective in an international trade transaction, when title, property and risk pass from a buyer to a supplier, certainly in the case of goods, and the rights to either party if the goods don't conform to the contract as agreed. And then misrepresentation, which relates to a situation where one party agrees to enter into a contract but later discovers some information which led them to commit to the contract was false. In financial services, transactions in particular, there's a concept known as the utmost faith, and essentially what they're doing is saying we've done this with the best possible good faith. So, for example, in a contract for motor insurance, the failure to provide relevant material facts about your driving convictions could invalidate your insurance cover. The case law concerned with purchase of land, which was, I guess there's a case study about farming 2,000 sheep. And that was the reason that they purchased the land. But when it wasn't, the purchaser sued. So it's therefore an opinion and not a fact in that particular case. It wasn't necessarily misrepresentation. But it arises when one party to the contract enters into it based on information, like someone saying, yeah, you can have it next day delivery, so you agree to it, and then turns out that they don't do next day delivery, and now they're trying to hold you to a contract. So the contracts can become voidable if the statement relied upon is found to be misrepresentation. An important principle of this thought is that it only applies to facts, not opinions. So that 2000 sheep example comes from the Bissett versus Wilkinson case. And the utmost good faith is the failure to disclose material facts can be significant in some contracts. Okay, we're going to talk about framework agreements now, which are actually not contracts. They're quite commonplace in the public sector. So the important thing here is that the agreement itself doesn't constitute a contract. There is no commitment to purchase anything. It concentrates on approval of suppliers with which contracts can be created thereafter. The contract is struck when the purchaser makes a call-off against the framework. Frameworks are often referred to as umbrella agreements, in that everyone owns an umbrella if you live in a country that rains, but you only put it up when it rains, and you would only use the framework agreement when you need to. So you use it for ongoing supply requirements, but when you can't necessarily determine what you're going to need or when you're going to need it. So the suppliers are pre-approved and agreed to participate in any call-off within a specific period of time based on the agreed terms. And it sometimes has an agreed price, but alternatively, participating suppliers might have to bid for a mini competition. So an informal framework or panel agreement is one where there are different types of contractual agreements that can be made between the customer and the supplier. So the advantages and disadvantages of having these informal frameworks or panel agreements are, it's quicker access to market, which means that from a buyer's point of view, that reduces the time for tendering. And from a supplier, they've got a better chance of winning the work because they've already been pre-approved. In terms of familiarity for the suppliers, there's ability to build trust through regular work for both the buyer and the supplier. Keeping the list up to date can be a little bit resource intensive for the buyer and for the supplier. And then the open access to the list of informal frameworks, which means that you've got the ability to include new discovered potential suppliers if you have this open access. Suppliers can apply at any time, but the downside is it becomes unmanageable and large, and there's quite a lot of resource requirements to vetting the suppliers as well. If you go for the mini competition route, the tender process is run under the framework agreement, and it's only open to the suppliers that are on the framework. And you can do it on a price-only basis or a combination of price and non-price factors. But then the call-off that happens underneath that, either as a direct award or a mini competition, is actually the contract. And that's the point where the contract is created. So you could have loads and loads of call-offs under one framework, hundreds if you wanted to, hundreds of separate contracts. All right, we're now going to look at service contracts. Now, in theory, contracts for goods and services are the same. However, contracts for services require different considerations due to the characteristics of services versus goods. Often service or quality can be subject to interpretation, so it needs to be catered for within the specification, the KPIs and the SLAs. So the same principles apply to both goods and services, but goods are tangible, which can be consumed and used, whereas services are intangible actions, which are generally delivered by individuals, but it doesn't result in the ownership of anything, as there's nothing physically created to own. So an example could be cleaning services or outsourced call handling services or security. And the issues are often when determining performance standards that are appropriate for the staff and to ensure consistency. And then we'll just look at different contracts for hiring versus buy-in. So assets can be purchased, hired or leased. Hire and lease are used interchangeably. But hire is usually used for short-term arrangements, whereas leases are used for longer-term contracts. So, for example, you hire a room for a meeting, but you lease an office for a building. So you would use this type of approach when goods are hired, the ownership is not transferred. The person or firm supplying the asset acquires them and then allows the person hiring them to use them for a period of time. The process of forming a contract for hire is quite similar to that of a contract for sale. There still needs to be an offer, acceptance, consideration, intention, and capacity. And many of the key terms of the service may also apply to the contract for hire, so payment terms, health and safety issues, insurance. But the areas to consider when drafting a contract for hiring an asset is the transfer of risk. Which risks do transfer to the hirer and which risks remain with the owner? So, for example, it might be normal that the hirer will be responsible to insure the asset, but the maintenance may be done by the company that hires it. The period of hire and the end of period arrangement, how long is it for? What happens to the asset at the end of that period? Who owns it? And then extending the scope, is it possible to add 2 additional photocopiers to an existing contract? And if so, does the contract end at the same time? Or do you end up with non-coterminous contracts? But what if you want to reduce the scope? Hire purchase agreements is where assets are hired for a period of time, but at the end of that period, the intention is that they will transfer the ownership. The transfer may be automatic upon payment of the final instalment, or it may be an option that the hire is exercised by paying a further consideration. In legal terms, the contract is a contract for hire for the full duration until the final payment or an option payment is made, and only at that point does it become a purchase contract. Now, not all contracts are outright purchases of an item. One option for a purchaser is to hire or lease, as we said, and it will involve paying the instalments. And this slide just shows you about the short-term leasing options. At the end of the agreed time, the company that hired it to you will take the asset back. The leasing ones are for the longer term, and again, at the end of the period, the leasee generally takes the ownership back, unless, of course, you've gone down the approach where final payment will result in the transfer of ownership of the asset. Because vehicles are often obtained by leasing, so that organisations will have them for several years. So that's the end of Learning Outcome 1. Thank you for watching today.